Thank you all for coming this afternoon. I'm Karen Engel, and I teach at the law school, and I co-direct the Rappaport Center for Human Rights and Justice, as well as the Sissy Baron-Gold Fund for Peace and Social Justice. And this is our final public event of the semester. So on behalf of our team and our co-sponsors, who are the Constitutional Studies program here at the law school and the Teresa Lozano Long Institute of Latin American Studies at UT, I'm pleased to welcome you to our event this afternoon on the constitutionalization of human rights law, implications for refugees. Before we begin, I'd like to recognize that we're meeting on the indigenous lands of Turtle Island. Moreover, I'd like to acknowledge that Alabama Kashota, Caddo, Caritza Kumacrudo, Wiltacan, Comanche, Kickapoo, Lipan Apache, Tonkawa, and Isleta del Sur Pueblo, and all the American Indian and indigenous peoples and communities who have been on or have become a part of the lands and territories we now call Texas. It's a real pleasure for me to welcome and introduce to you all our featured speaker, Steve Meili, who is James H. Michael Chair in International Human Rights Law and Assistant Dean for Clinical Education at the University of Minnesota Law School, where he also serves as co-director of the Immigration and Human Rights Clinic, and somehow found time to come be with us today. So Professor Meili teaches and writes extensively in the areas of U.S. immigration law and international refugee law. And much of his writing is comparative and focusing on the refugee law of actually an extraordinary number of countries he's written about in terms of the refugee law. And his book that will inform today, his talk today, is very much in that vein. It's titled The Constitutionalization of Human Rights Law, and it came out by Oxford University Press in 2022, and we can have a show and tell here. The book compares the strategies used by refugee lawyers in 5 countries: Colombia, Mexico, South Africa, Uganda, and the United States, with a particular focus on their use of national constitutions to promote human rights law. After Professor Meili speaks about his book, we'll have the pleasure of hearing comments from not just one, but 2 people. Both are Rappaport Center regulars and steering committee members, and they'll bring different perspectives of their work to the book. So first will be Denise Gilman, who's clinical professor and co-director of the Immigration Clinic. And I think some of the students, or Melissa students, are here today. Raise your hand if you're in that class. They're taking roll. Okay, welcome. And yeah, so Denise organized today's event, which we're very appreciative of. Invited Steve to come, convinced him to come. And she's also been a fairly long time interlocutor of his. And so we're eager to hear what she has to say about his work. And then we'll hear from Dan Brinks, who is professor of government and law and chair of the government department here at the University of Texas. And he writes extensively in comparative constitutional law and comparative politics. So he'll bring that angle to the discussion. So with no further ado, join me in welcoming Steve Meili.
Yeah. Thanks very much, Karen. I appreciate that introduction. It's great to be here. This is my first time in Austin, and after Denise took me to Black's Barton Springs, I realized I learned that there are 2, but the Barton Springs one, I may never leave. It was great. But it really is a pleasure to be here. Thanks to all the sponsors of this event, and particularly to Denise and to Dan and Karen for participating in the event. And it's great to see some other old friends here, and students as well. It's not that old. No. But anyway, it's wonderful to be here, and I've enjoyed the time very much. So as Karen said, I'm going to talk about the book. There's the cover. on the constitutionalization of human rights law. And as I always tell students, it's nice to have a roadmap at the beginning of a talk. So what I'll be doing today, and also now that I know that I'm standing between everyone and the final installment of this series, I'll try to make this as quick as possible. Anyway, background on constitutionalized human rights law is what we'll start with. Then I'll talk about the methodology of the study, its major findings. We'll talk about the continuum in a bit. Sounds a bit ominous, but I'll explain what that is. Cause lawyering practices, the kinds of practices that refugee lawyers in the country studied engage in, and what we might learn from that, not just here in the United States, but elsewhere, and some commonalities between those practices. And then the all-important why this matters, or who cares, which we always try to get to, both in terms of theory and practice. But first, I'll talk a little bit about what drew me to this subject. As Karen said, I've spent a fair amount of time doing comparative refugee and asylum law work, looking at a variety of countries, both common and civil law countries in that regard. But I'm also a clinician, so I co-supervise a clinic where we do primarily asylum cases. And I've always been incredibly jealous of lawyers and clinicians in other countries who have this panoply of human rights law that they can cite to and utilize in their work. Whereas, we have the Immigration and Nationality Act, and you take a big risk if you even cite to the Constitution. We'll talk about that in a little while. So that led me to want to study what refugee lawyers in other countries do, what strategies they follow, whether it makes any difference that they have all of these constitutionalized human rights laws at their disposal. And why I think this book, this kind of study is important right now. So a little bit of background on that. Much of this, I'm sure many of you are familiar with, given your work in school, and obviously the folks who do this in their professional life. As of mid-2023, there were 110 million displaced people throughout the world, more than 42 million of whom were either refugees or asylum seekers. And that number, of course, will just continue to grow. At the same time, and in part certainly because of that growth, countries of refuge, especially in the global north, developed countries, are doing all they can to prevent people from entering the country to even apply for asylum, much less get it if they are able to actually apply for it. So we see, for example, the policy in the UK that they're trying to put forward in terms of rerouting asylum seekers to Rwanda. That's been held up in the courts, but the UK is still trying to find a way around that. This week in particular, some legislation exactly on point. Australia's offshore detention and processing policy, or the Biden administration's policy, preventing anyone from applying for asylum at the southern border if they haven't previously applied for asylum in a so-called safe third country along the way. So in addition to these kinds of trends, which have been certainly followed, copied in other parts of the world, refugees and asylum seekers, of course, are being increasingly demonized by conservative politicians, right-wing media outlets, stoking xenophobia for electoral gain. So certainly we saw in the run-up to Brexit, one of the main talking points of Brexiteers was stoking fears of immigration. We certainly saw that in the anti-immigrant rhetoric in the election of Trump in 2016. We're seeing a return from it in the possible re-election of Trump in 2024. And again, we see similar rhetoric in other countries throughout the world. And this, of course, is not going to stop anytime soon, particularly as climate change and armed conflict just increases the level of migration from folks from their country of origin. Meanwhile, the main human rights vehicle for protecting refugees and asylum seekers, the 1951 Refugee Convention, has proven to be inadequate to combat these forces in any meaningful way. Many asylum seekers certainly receive protection in individual cases, including some of the ones that you all work on here in clinic. And that's because most states have ratified, incorporated the convention into their domestic law. But it's the individualistic grounds for asylum under the Refugee Convention and limited grounds for protection are no match for the unprecedented numbers of individuals fleeing home for a variety of reasons. And it's been difficult, if not impossible, for states and advocates to keep up with that through the use of the Refugee Convention. So the puzzle that I get to in the book is how human rights law that has become increasingly enshrined in national constitutions might provide an alternative and perhaps more effective way for refugee lawyers, at least in certain countries, for representing their clients. Because with that constitutionalization, international human rights law is no longer this construct from the outside that's imposed on countries or attempted to be imposed on countries and which they resist. Now, once it's in the Constitution, it's part of the domestic law and presumably enforceable in domestic courts, and would certainly, one would think, have more bite. So talking about the constitutionalization, it's on the rise throughout the world. More and more states are including human rights provisions in their constitutions, usually in two ways. Sometimes it's individual provisions that they put into the Constitution, or they will incorporate entire treaties and make them part of the Constitution. That makes human rights treaties like the Convention on the Rights of the Child part of the domestic law of that country, which again, potentially could be quite powerful. Now, this constitutionalization is the subject of a lot of studies. There are these so-called large N studies where scholars try to find a statistically significant relationship between constitutionalized provisions and human rights performance on the ground by states. The results are all over the map, and in some cases there has been such a relationship shown, but in many others there has not. But the important point for today is that we know virtually nothing about how constitutionalized human rights law affects asylum seekers in particular, and how refugee lawyers use those rights to protect their clients, i.e. how do they bridge the gap between these lofty sounding human rights principles that are in the Constitution and what's happening on the ground. So my interest in that puzzle led me to analyze the factors that contribute to the effective use of constitutionalized human rights law in the refugee context and those which detract from it. So I selected 5 countries for the study. As Karen pointed out, they are highlighted: Colombia, Mexico, South Africa, Uganda, and the United States. Why did I select those 5? For a few reasons. All are dealing with either long-standing or recent, particularly in the case of Colombia, refugee crises of one sort or another. Each has a national constitution with varying degrees of human rights, varying numbers of human rights provisions. Mexico has 81. The US is on the low end of this, at least of this group, with 35, which actually surprised me that we had that many, but anyway, there's 35. Each has a functioning judiciary with varying degrees of independence from the executive. And each has a dedicated group of lawyers committed to protecting the rights of refugees and asylum seekers. Here in the United States, we have thousands of them. Several of them work at the U of T. In Uganda, there's a handful. In fact, one of the things that's fascinating about the study is that just inverse correlation between the number of human rights provisions available in the Constitution and the number of lawyers available to actually try to enforce them. But that's another story. The methodology was a series of open-ended interviews that I did with 50 refugee lawyers in the 5 countries, and how they utilize constitutionalized human rights provisions. All of the lawyers were guaranteed anonymity. And here's a situation where the pandemic actually helped, because I had a grant to go to each of these countries, at least the non-US ones, and I was prepared to go, and then COVID hit. So all of the interviews were done via Skype, because this was pre-Zoom for the most part. The thing about that was interviewees had nothing else to do but be interviewed. I mean, it was easy to track them down. They couldn't avoid me after a few emails. And so they were, for the most part, happy to talk. Obviously, you lose the national context when you can't do on-site interviews, and I recognize that as a limitation of the study, but it had to deal with that because of the timing. But I probably did increase the number of interviews that I was able to do, and the length of the interviews. Folks were willing to talk longer, I think, because they were sitting at home or whatever, right? They were willing to talk. So what are the main findings? So the first is what I call the constitutionalized human rights law continuum. And came to this realization after going through all of the results of the interviews. And by this, I mean a continuum of ever more ambitious stages through which refugee lawyers travel in representing their clients. So it has 4 stages, as I recognize. First is just the mobilization of cause lawyers who represent individual clients, but also a larger cause, in this case, the cause of refugee rights or the rights of asylum seekers. And I apologize, I will be conflating those 2 terms, and folks who certainly know this area of the law know that there's a difference between refugees and asylum seekers. Just for today's purposes, I'm often conflating the 2. Anyway, so stage 1 is just to have that cadre of lawyers who are representing refugees, which is not the case in all countries in the world, but certainly all 5 of the countries in this study have made it to this stage. Stage 2, kind of the low-hanging fruit stage, brings to mind Hannah Arendt's notion of the right to have rights. That is the country, at least the highest court and the apex courts have recognized that non-citizens and asylum seekers and refugees in particular do in fact have constitutional rights. That's not always a given in all countries, including some of the ones that are included in the study, and we'll talk about that a little bit later. Stage 3 is expanding the scope of those rights. So it's not just that refugees and asylum seekers are entitled to constitutional protections. That's important, but more important is, what does that actually mean, and does it have real significance? And so it's where the advocates, where the lawyers are making sure or attempting to make sure that the Constitution entitles refugees to something meaningful like healthcare, employment, education, and the like. And then stage 4 is the ever elusive implementation stage. Nearly all the lawyers, certainly in all the countries, complained about this. They can win cases, achieve legislative victories that look good on paper, but they are rarely implemented effectively because of various obstacles. Often, certainly resource obstacles in some situations, particularly in Colombia, I would say, but also because of hostile governmental agencies that are tasked with actually enforcing these decisions. And the biggest example of this, I'll get to in a second, is South Africa, which has quite a successful record in this area in terms of constitutional court decisions, but very poor implementation. Yeah. So those are the 4 stages of this continuum. Lawyers in each of the countries use a variety of tools as they move along that continuum, and that depends on the political, social, legislative, legal context in which they find themselves. And that was one of the overall findings of this book that I found, heartening as a asylum lawyer, is the creativity that lawyers demonstrate, given the limitations under which they operate. It's really quite inspiring, given what they're fighting up against. Okay. So what do we know about how do each of the 5 countries situate themselves along this spectrum? There's a continuum, and I'm just going to give brief snapshots because I don't want to take too long, certainly, going through this, but just to give you a little bit of a taste of this. So Colombia, with millions now of refugees and migrants from Venezuela, the latest data about 3 million. Many human rights provisions in the Constitution, but the constitutional law continuum is stage 2, sort of, but actually moving beyond that. Okay, where what we have now is a recent decision by the Constitutional Court in Colombia recognizing the right to health care. And this is very important. Obviously, the difficulty is implementation of it, but it's certainly a movement in the right direction. We'll talk about that case in a little more detail. later. Okay, then we have Mexico. Oh, I just realized I mixed mixed the stages of Mexico and Colombia. Colombia is at stage 3 because it has identified a specific constitutional right, right? Not just that asylum seekers and refugees have constitutional rights, but the right to health care is something to which they are entitled. So that would qualify as a stage 3. It's Mexico that's at stage 2, sort of. And the reason I say that is there's only one case involving refugees and asylum seekers that has made its way to the Mexican Supreme Court. And that was a challenge to Mexico's 30-day deadline for applying for asylum. And so all of you, any of you who have done asylum work in the US know that you have a year to apply for asylum in the US, with some exceptions. That seems like a short time. Right? Way shorter than most statutes of limitations and under US domestic. But 1 month is really crazy. And so trying to put together an asylum claim within 30 days is completely unrealistic. Anyway, that was challenged by a law clinic in Mexico City and by an NGO. And the Supreme Court eventually heard it and said that no, that limitation does not impede the right to asylum, because Mexico has a right to asylum. And the court, for a number of reasons that I won't get into right now, declared that did satisfy the constitutional right, or didn't violate the Constitution to asylum. So Mexico barely at the stage of recognizing that refugees and asylum seekers have constitutional rights at all. South Africa, very interesting case study here. Beyond stage 3, because, as I mentioned earlier, the Constitutional Court and some of the other high courts in South Africa have issued several decisions that are that establish the rights, substantive rights for refugees and asylum seekers, education and work, most notably. The Constitutional Court, particularly in the immediate aftermath of the fall of apartheid, was quite progressive. And actually a lot of folks who had worked against apartheid, a lot of lawyers, once that regime was defeated, they started to work on immigration law and refugee rights. And so they brought a lot of the theories and tactics to their work on behalf of refugees, and they're quite successful. But South Africa's Department of Home Affairs is notorious for quite openly defying Constitutional Court and other high court decisions, saying that refugees are entitled to various rights. They just refuse to enforce it and kind of wait for the government or advocates to do something about it. And so it was interesting talking to the lawyers who felt very frustrated. They felt mostly what they were doing is playing defense. And I know a lot of US lawyers in this area think that too, right? What we're mostly doing, we're not really advancing the ball very much or advancing rights. You know, we're just holding on to what we have. And that's what they feel like in South Africa. And so they're often left with this really difficult choice of suing the Department of Home Affairs for contempt because its refusal to go to follow through on a Constitutional Court decision. And the problem with that is it costs money, it takes time, it's often futile in the end, and it also just feels like we've already won this case. Why should we have to continue with this procedural motion to get the government to do what it was supposed to do? So going into the study, I thought South Africa, the lawyers it'd be like the most optimistic bunch because they won all these cases in front of the highest court, but they may have been the most depressed set, which is interesting. Okay, Uganda, totally different situation, and for a couple of interesting reasons. Here I say approaching stage 2 because there are no high court cases in Uganda recognizing that refugees or asylum seekers have rights under the Constitution. Okay? And there are many constitutionalized human rights provisions in Uganda. But for a couple of historical reasons, lawyers in Uganda take a different approach. First of all, there are not very many of them, as I mentioned earlier. So they would have to pick and choose cases very, very carefully. But the other thing is an institutional survival aspect, because the main the main refugee rights NGO in Uganda was shut down for about 6 months or so, about a decade ago, because it challenged government policies with respect to LGBTQ asylum seekers. And because of a very broad governmental law that allows for, non-governmental organizations to be shut down if they threaten national security or whatever it is, they were shut down. So they have to be very careful when they challenge the government in any way. So they take a much more collaborative approach where they sponsor training sessions with judges, with immigration enforcement agency personnel, etc. In their view, it's worked. They've certainly, among the judges and the other officials, there's much more of an understanding of the rights of refugees, but they're very loath to engage in any sort of conflict-based advocacy. Interestingly enough, I don't know if it has anything to do with that, but of certainly the countries in this study, Uganda is the only country that offers per se refugee recognition, and this is in the case of South Sudanese. So if you're from South Sudan, all you have to do is show that you are from South Sudan and you will be given refugee status in Uganda. They're quite proud of that. They've gotten a lot of international money because of it. There's been some controversy over it, but that is sort of one of the hallmarks of their policy. Okay, and then the United States. Well, I'd say the most interesting interview and I suppose revealing interview that I did with the United States was with a very prominent civil rights and immigrant rights attorney who's been doing this for about 30 years. And when I asked this lawyer about the use of international human rights law in practice, in that lawyer's practice, the lawyer said, well, I hate to say this, but I've been doing this for 30 years and I know virtually nothing about international human rights law. And the reason I mention that is because we really don't have to, at least traditionally, refugee lawyers in the States haven't really had to know very much about it because it's not applicable in US courts for the most part. And in fact, as a couple of lawyers noted, if you do raise not even an international law argument, but if you raise a constitutional law argument besides something like due process, you may get laughed out of court, and the judges will wonder what's wrong with your underlying case under domestic law if you have to resort to international law. This was also one of the arguments when I did an earlier study on refugee lawyers in the UK, where they do have a human rights bill and it incorporates the European Convention of Human Rights. So they're used to utilizing international human rights law, but they have to be very careful because many judges will think that they don't have a very good case if they have to reference international law. So really, the reason why I have it at stage 4 is, of course, the US Supreme Court has held since the late 19th century that non-citizens are entitled to constitutional protections like due process. But those rights are so narrowly tailored that they don't carry much weight. Basically, the right to some kind of a hearing before someone is deported, but that right has been applied very narrowly and increasingly narrowly, as we know from some recent US Supreme Court cases. So that's kind of a snapshot of the 5 countries in the study. Happy to talk more about them as we go forward. All right, and want to talk a little bit about the lawyering strategies before we finish up. And again, these were common to pretty much all the countries. It's interesting to hear this. We've already talked about low-hanging fruit. First established that refugees and asylum seekers have constitutional rights to begin with, because that's not a foregone conclusion. In a lot of places hasn't been. And then go from there. Educate judges. This is interesting. Certainly in Mexico and in Colombia, there, prior to the last 5 or 10 years, not much of a history of refugee law and asylum law in the courts, in the domestic courts in those countries. So a lot of the lawyers spoke, they feel that's part of their job is to educate judges, and that they realize there are going to be some defeats along the way, but the larger cause or the larger purpose is to at least start a dialogue with the courts, and that eventually that will lead to greater victory. So they take some solace in that, even with an individual loss in an individual case. It's at least a way to start the conversation going with the judiciary. Choose sympathetic clients. Of course, that's a strategy in pretty much all areas of the law where you're representing plaintiffs, right? You try to do this as much as you can. Most lawyers in most of the countries talked about children and women in particular, that if you can have claimants in those categories, you're going to have greater success. And we'll talk about that a little bit with some of the specific cases. But of course, as we know, here in the US, you don't always have a choice about who your clients are going to be, particularly for cases that reach the appellate level and are going to potentially have some larger impact. Several lawyers talked about the human rights cocktail. I think we should have one after the lecture today. Why not? This is where they use a variety of these human rights provisions. It's really interesting. Due process, right to fair process, human dignity, which is in the South African Constitution. Social and economic rights. And it's not so much throw everything against the wall and see what sticks, but they do cite a lot of human rights provisions. Certainly South Africa, Colombia, Mexico have done that. And sometimes they're a bit surprised by what the judges will grasp onto. South Africa in particular, the right to human dignity is huge in the decisions in South Africa on entitling refugees and asylum seekers to certain specific rights. Another strategy is focused on rights enjoyed by everyone, not solely refugees and asylum seekers. So there's some conscious decisions, like in Colombia, right? Healthcare is something that's enjoyed by all Colombian citizens and now non-citizens alike. In contrast, the case in Mexico, where the Supreme Court upheld that 30-day deadline for applying for asylum, that's a right only pertinent to or pertaining to asylum seekers. Framing the narrative. This was a huge task that lawyers in this area feel that they have because of xenophobia, because of the depiction of refugees and asylum seekers as anything, as everything from criminals, rapists, fraudsters. It's a term in the UK prior to Brexit, that people are using asylum more and more as an end around the regular immigration process. All you have to do is declare or claim asylum at the border of whatever country you're trying to enter, and you're suddenly, given all these rights and privileges that you're not entitled to, or that other immigrants are entitled to. So fighting back against that is a priority for a lot of the lawyers. They focus a lot on discussing individual cases, trying to, describe things in more human terms, but they see it not as a losing battle, but it's very, very challenging, particularly because of the ability of forces on the other side and a lot of the media to frame things in very frightening terms. And finally, avoiding cases involving national security, because governments, particularly those who are trying to keep immigrants out, love to frame the immigration debate, the immigration issues as matters of national security. And whenever they have an opportunity to do that, they will. And so this goes along with the sympathetic clients. The lawyers in all of the countries try to take cases where there is not a national security element. That is becoming more and more difficult. Again, as more and more governments start to frame the immigration debate as a matter of national security. In terms of how these have played out, we already talked about Mexico in terms of the rights applying only to asylum seekers and how that's not as effective a strategy. The claimants in the Colombian right to healthcare case were a woman with uterine cancer and a boy who had been denied hernia surgery. So Both of them have been denied healthcare under Colombian law. The challenges were made on their behalf, and they were the vehicles in a sense establishing that right. Okay, finally, what does this matter? Who cares? So on theory, as I mentioned before, most of the studies in this area of constitutionalized human rights law are large N studies, quantitative studies, numbers crunching. They certainly have a role, but they're limited in what they can tell us about what's really going around in countries. And so this study, and I hope others like it, will demonstrate what really is going on the ground, both in terms of what courts are doing, how they're applying constitutionalized human rights law, but also how lawyers are utilizing it on behalf of their clients. What strategies work, what don't, how do they adapt to the political, social, economic, and legal context in which they operate. And then as to practice, as I mentioned earlier, right now we find ourselves in a situation where there are more refugees than any other time in history, yet simultaneously countries of refuge are ignoring their obligations to protect those folks. And the traditional instrument for protecting them, the 51 Refugee Convention, has proved inadequate, particularly in the face of phenomena such as armed conflict and climate change. So this makes domestic law, and particularly constitutional law, perhaps the last best legal move, at least, for addressing these issues on a larger scale. And I hope this study and others like it will provide more information on what lawyers in a variety of national contexts can do and utilize these provisions for their clients. Thanks very much.
So thanks so much for that, Steve. I first had the opportunity to read the book for a kind of a commenting session at a Law and Society meeting in Puerto Rico. And so I didn't get to actually see Steve present the book, really. We just kind of jumped straight into commentary. So it's nice to see it presented. Thank you very much for that. And thank you, Karen and Rappaport Center and all the folks for setting this up, and also for the Center for Constitutional Studies and LILAS for sponsoring it. So I loved the book again when I looked at it preparing for a few comments today. And I think one of the things that I like most about it is just, sort of how much it brings together refugee law, constitutionalization of human rights, and importantly, cause lawyering. I kind of wish the title could also fit in cause lawyering, but it's already pretty long. But it's something like cause lawyering and its implications for refugees after the colon. I don't know, something like that. But because it is such an important part of the work, and it's something that's not often considered in looking at applicability of international human rights law in domestic spheres or in general. I almost see it as a bunch of different axes. I mean, there's all these different things that are playing into one another: the human rights piece, the constitutional piece, the lawyering piece, press, societal expectations, and how they kind of fit in with each other determines where refugee rights are implemented or aren't implemented. It's sort of not a sliding scale, although the continuum is very persuasive, but it's, kind of this mix of things and how they all intersect that gets us where we are, whether that's good or bad. I am particularly taken by the comparative work, the effective way in which you look at 5 different countries and compare and contrast them without falling into a trap that I think is pretty easy for most of us, including me, who's done a little bit of comparative work, not as sophisticated, of, sort of suggesting that one system is more of a model for other systems, is better than other ways, or even bits and pieces of particular systems, or the way that other systems should go. And I think that's really complicated, of course, for lots of reasons, but mainly because it often, one, compares apples to oranges. So you have to kind of look at the entirety of a system to understand how any particular component works. but also importantly, because it doesn't take into consideration as fully the societal context in which those particular systems are operating. And here, there's a lot of nuance to the ways in which you talk about levels of xenophobia or support for immigrants' rights in the society as being significant determinants of whether or not the systems as they're drawn up are actually going to be impactful in protecting refugee rights. And so overall, I think it's fair to say that one of the important things that the book does is to really kind of complicate a little bit more that age-old question of how do we get past the gap between law and practice, right? That's a gap that we identify all of the time in general, and certainly in the human rights sphere. And here you look at it from a range of different perspectives, but importantly from the perspective of what is the role of non-state actors. So I think typically when we think about implementation gaps, we think about it as the state or state entities' failures to fully implement measures that are on the books. And there is some of that in here as well, as you just described with South Africa, that even if you've got the norms, you know, the state actors might not implement them. But you also look to ways in which non-state actors impact the level of implementation for good and for bad, to be clear. So that includes, importantly, again, cause lawyers, lawyers in general. One tweak that I would make if I had it, you know, all the way I want it to be, is that I would, and I mentioned this before, mention not just kind of the impact litigators or big policy-making lawyers, but also the direct representation lawyers who, as we know, and I know you've looked at this in some of your work, who also engage often at the key level of kind of that initial laboratory of the trial stage. They engage in the practice of trying to bring down international human rights norms into practice, sometimes successfully, sometimes not. And then ideally also feed up their experiences, our experiences on the ground of representing asylum seekers into what's needed for the larger impact litigation and other strategies. So I'd add that in too. But you don't stop at lawyers as non-state actors with important roles in determining implementation. You also look at other elements of society. I already mentioned sort of the society in general and levels of xenophobia or not, or support for immigrant rights. You mentioned, of course, NGOs in general, sort of civil society and refugee rights organizations, acknowledging that world is more than just the lawyers, that it also involves those who do social science work and storytelling around immigrants' experiences, refugees' experiences, and then also the press, the role that the press plays, both in sort of a intermediary target for lawyers seeking to activate the press to then activate implementation, but also maybe somewhat separately as influencing the overall environment in which systems are coming into play. And so that seems really important to me, to think about how all of these non-state actors come into play. In the same way, or kind of in this same vein, the book also complicates the implementation gap by thinking about it not as just sort of one gap of, okay, here's the international human rights norm, and is it implemented or not, or even, you know, constitutionalized human rights norm, and is it implemented or not, but rather looking at kind of all the different places where there might be a gap. So that's, you know, human rights treaties adopted into domestic law or not. Okay, adopted into Constitution, but maybe not adopted into other domestic norms on the ground. And then, okay, maybe adopted and really great case law on the interpretation of international norms, but then not getting implemented by state entities. And then, you know, kind of all the way down to, you know, what does it just look like on the ground in terms of refugee rights? And that that's really useful as well. I think it's interesting that you use, I mean, I know it's your world, but the refugee world is the way to analyze this, because it is a bit complicated. You closed just now mentioning the fact that, of course, there's this separate body of refugee rights law, the 1951 Refugee Convention and the law surrounding that, that exists kind of in parallel to other human rights norms, and very much they interact, but they are these separate bodies. And so in some ways, it makes it a more difficult story of, to what extent are we really furthering rights by bringing down international norms into constitutions. But in other ways, I think it makes it more interesting and even richer to recognize that it's not even just one set of kind of international rights-based norms that we're looking at, but potentially two that might have different weights and might play into things differently. And then I did want to just think for a minute about Mexico and the US, partly with that framing of refugee versus human rights more broadly. Partly Mexico and US, I mean, that's what we know best here. And we work on that all to a great degree, the situations involving Mexico and the US. But it's interesting that in some ways, of your examples, and correct me if I'm wrong, but I think Mexico and the US are the only ones that actually even really take up true refugee rights. In other words, access to asylum, access to the asylum process, as opposed to, for example, Colombian healthcare or South Africa and the right to work, which are, they're certainly human rights and refugees are being affected by them, but they're not exactly refugee rights in the sense of access to the system. And I think Mexico and the US, it's interesting that they're the two countries where that is the actual right at play. But it's also interesting because they're almost opposite examples, I think, in this way. So Mexico, I believe, the incorporation into Mexican constitutional law of human rights in general and refugee law is relatively new. Am I right about that? I'm not making that up, right? Yeah. It's been a while since I've studied Mexico constitutional law. I used to know it. And I know it's some of it's in the book, and then the US is kind of the opposite. So in the US, of course, we've had our constitution with whatever rights are in it for many, many years. And in fact, some might argue, for both good and bad, that much of international human rights law and less so refugee law, but a little bit, derives in different, and is morphed into something else, but initially kind of gets some of its foundation in the US system. And yet the US system is where it seems that's kind of the least relevant, the ability to invoke, kind of constitutional norms and human rights norms in the US system. And I think I agree with that, although I do think there may be a little bit of movement on that in some instances. So that's just a thought as well. And then I just want to end it on a note of definitely supporting the idea that there are some real practical implications for this. I mean, I'm thinking really selfishly and concretely that, we now have to show that people either, sought asylum in another country, or somehow, both for advocacy purposes and for individual case purposes, were sort of prevented from it. And by not showing us just a glowing picture of other systems, you help us in that effort because we're able to describe some of the deficiencies, some of the shortcomings of the systems in other countries. And then the second place where I think it's practical is that it inspires everybody in this room because it does put such an emphasis on the role that lawyers can play as non-state actors, although some will go to government, but as non-state actors in shaping refugee policy and improving rights for refugees. And I think that's a really, really important statement, and also kind of a bit of a template, always plenty of room to continue to think about exactly what are the best strategies, but certainly helpful in that. So thank you again for your work and for being here.
Right. So thanks again. Yeah, thank you to the organizers for inviting me to be here. Thanks, Steve, for coming and joining us here. It was I didn't engage with the book as deeply as maybe Denise, but I did skim through it, and I find it super interesting. It's reminiscent of what we've often talked about in terms of vernacularization. So the sort of process of taking this stuff that's all in the international sphere and bringing it somehow to land inside a country. Sally Engle-Mary wrote about that quite a bit, and others. And it shows, at least it goes into quite a lot of detail on at least one set of actors who do that kind of vernacularization work, the cause lawyers, and particularly the work that they do in courtrooms. But also others, and I'll say a little bit more about that. So what do I think of when I think of this work of vernacularizing international human rights law? I think of what happens to that international human rights law in the process, right? It's a process of sort of translation, interpretation, transformation in some ways, right? Maybe it changes the meaning sometimes, or at least it changes the emphasis. We did a project a couple of years ago, maybe 3 years ago now, on the right to water, and we were looking at how different people were using that, from Flint to informal settlements in India, and it was obvious that the people using the language of rights were really thinking about really different things along the way. So I guess one question for you is, which I'll get to in a minute in more detail, is, how do you see that process happening, right? What is happening in that sort of process of vernacularizing international human rights law? So that's one of the things I think of, is like, how does international law get transformed in the process of lawyering it and bringing it to earth? And the other thing I think of is that, why go there at all if you're a lawyer in a particular domestic context, right? It seems to me, the law that you work with is sort of on a gradient of sensitivity to local political conditions. You have like the executive making policy decisions and deciding on kind of implementation and enforcement, and then you have maybe regulations and then statutes, and then the Constitution is supposed to be like maybe more rigid, and then international law is maybe most remote politically and least subject to local local influences, but at the same time also most remote and most difficult to make land. So why do you think, can you say a little bit more maybe about why you think the lawyers in these cases kind of reach out beyond their own political community for normative support in the work that they're doing, right? Like and is that ever going to work? Right? Because one of the things you say is that regardless of the country, every lawyer you talk to said, well, at the end of the day, it all kind of runs a little bit of ground on the implementation rock. And so that's the question, right? So if in a way, right, I realize it's not that, but in a way, the continuum is either sort of a continuum of success or a continuum of increasing desperation, right? Like trying to reach for stuff that's not already here. So is that a fair way to think about it? Is it really because we're really short of something that we need in the domestic context that we start to reach out beyond it further and further beyond? So a couple of questions kind of based on that way to think about the process of domesticating or vernacularizing international human rights law. One is, what does international law add to the mix of things? So one is, once you bring it into the Constitution, right, you're likely being somewhat selective in what you bring in and so on, but you're bringing in particular provisions, right, particular rules, standards, whatever. But when we think of reaching for international law, and this is something we saw in the right to water context, you're also reaching out beyond your own community for other actors who are active in other places who can maybe bring their own networks and so on. We think of them as epistemic communities, and so they bring in not just sort of actors, but also the knowledge that they have and concepts and arguments and ways of thinking about things. So does that happen, right? Does the international sphere sort of come into the domestic sphere and start to transform it that way? We think of international law as adding venues, right? So that if you run out, particularly, I think in the inter-American context, if you run out of venues in the domestic sphere, does this give you the option to go up a level, right? And find an international court to maybe challenge what's happening in the domestic sphere? Does that give you additional options, maybe? And have you seen anybody doing that? Because that's something that I think human rights lawyers in Latin America in particular have done a lot of, right? They've often sort of pushed it all the way up through and then beyond the domestic sphere. So do you get new venues? Do you get new actors, new concepts, new ideas, new resources, right? Do you have access to new money if you're speaking human rights language, right? That you wouldn't have if you were just using a statute. So how does it help beyond just this idea that you might get a judge to agree with you on a particular? Then the question is, the next question, I guess, is how does it work in the other direction as well, right? Do we sometimes see this transformation of international law in the domestic sphere sort of filtering back up into the international sphere? Do we learn things by trying to make it work in a particular country that then we take back into the international arena to transform international law itself? I think people have said that happens in other areas in Latin America where, you know, courts that are working with very similar rights and constitutions come up with certain interpretations of those rights, ways to apply them and so on. And then the Inter-American court sort of sees that and incorporates it, and then it goes down into other countries, right? So is there this sort of bottom up, top down kind of recursive effect? I mean, maybe I think it goes beyond your book, but maybe you've seen it in talking to lawyers, particularly if lawyers have been trying to engage with international. So I mean, one place, and I don't know enough about the international regime to say whether it's already there or not, but it seems like the South African focus on dignity, human dignity, also in Colombia, right, in their constitutional rights thinking, does that filter back up into the international sphere? Could it transform the way we think about refugees or asylum seekers? So another way that I was thinking of, so you mentioned one of the strategies that people use as being educating judges, and there's a great book. I'm going to make a plug for it. Who's my former student, Ezequiel González Ocantos, wrote this book. You know him?
Yep.
Yeah. Okay. So it's a great book about how kind of human rights activists in Latin America met up with judges who were wedded to sort of ideas of the law and due process and you know, kind of how law works, that got in the way of creating more sort of legal criminal accountability for past human rights violations, and how they worked to first educate the judges and then sort of call out the judges who were willing to be educated, and then working to appoint new judges who would be more receptive. And you know, that's like taking this idea and really kind of making a systemic project out of it, right? To say, look, in Uganda, we have judges who are not interested, certainly in the US, we have judges who are not interested in international human rights law. Maybe we can start working on that to craft a new body of judges. And I don't know if you saw any of that kind of happening. It seems unlikely to me, because I think the the movement that produced the changes that Ezequiel is talking about was a much sort of bigger movement than the small group of lawyers that you find in Uganda, for example. But maybe there's some of that going on. The last question I'm going to ask, I'm at 10 minutes, so is one you told us you didn't want to answer, which is which is the one about success, right? Which is, does this work? And are you likely to win this way, right? So in part, your continuum is a measure of success, at least at the judicial level, right? And then it runs the ground, it runs up against kind of realities on the ground. But is that a temporary problem, right? I mean, are we eventually going to get around to these recalcitrant, bureaucrats and whip them into shape? Or is this something that's just always going to be kind of more subject to the local political conditions and local resistance and local sort of rhetoric and, responses to refugee crises and lots of people coming across the border?
So I'm going to move over there so I can see people. We have about 25 minutes for questions, but I imagine you have something you might want to say in response first.
Sure, although I'd love to hear other questions that want to take up
Well, do you want
too
to?
much time. I could try to go quickly, although a lot of the questions are involved, and I would rather evade some of them.
Just answer the success question. And then I'm going to take your seat so that I can see
Sure.
people who want to
Okay.
ask questions.
Let's see if I
And
can-
just to say that we like to do a 2-finger rule here, which is that if you have a new question, raise 1 finger. And if there's a conversation going on that you'd like to contribute to, like, oh, I just need to follow up on that, raise 2 fingers and don't abuse it, but you'll get to
Jump the line.
jump the line. And it's a great thing. I don't know most of your names. So I'll have to do some pointing, but anyway, I'll sort of do one look around and I'll look around again and people will poke me if you get their attention. Okay.
Great. Okay, I'll try to do a lightning round on the questions that Denise and Daniel raised, or the points that they made. Denise, you're absolutely right in your observation about Mexico and the US, where the cadre of lawyers is much more involved in sort of individual cases and access to the asylum process. And I made a conscious decision in configuring the study to focus more on rights beyond access, because that it was more generalizable to other countries where it isn't as much of an issue, or at least that the high courts are not engaged in an issue as much as they are certainly in the US. But certainly that kind of work would lend itself to another study for sure. And it'd be really interesting to see how constitutional law plays into that. So I thought that was a really good point. And it also reminded me of a comment from a lawyer from Mexico who said, our cases are all about due process all the time. And so, and a lot of that had to do with access to the asylum process and the due process implications of that. And I'm only going to answer the questions I'd like to answer. This vernacularization, that's fascinating. And the why questions, why go there at all? And I suppose it flips that answer that I referred to with the lawyer saying, I'm ashamed to admit, I've been doing this for 30 years and I don't know anything about international law. And I always view that sort of pejoratively, like, oh, this shows how little US lawyers care about this stuff, but why should they if it doesn't matter, right? And I would have to think more deeply about how lawyers in the other countries vernacularize, if that's a word, the law in their practice. That's fascinating. I don't have a rapid response to that, but what happens to the law in that process and how it's interpreted by the courts, and then how it's interpreted by the lawyers, and then how it's interpreted by the bureaucrats that are supposed to implement it. And it's understood by people whose lives are affected by it. It's interesting stuff. In terms of why lawyers follow this continuum that leads to I think the rock of implementation or something, or lack of implementation. I don't know whether it's because lawyers, and I mean, I've done a lot of work on closed lawyering, Denise referenced. And the one thing that's always impressed me is how, on the one hand, they're quite cynical, as I'm sure many of you are, but they're also quite hopeful, which is inspiring. And I think that's part of it, that they understand the challenges and how daunting this is, and they still do it. And folks in this room still do it. And that's, I mean, as a professor in this area, it gives me some hope as well, but right, because if they looked at these studies, they might wring their hands and say, why am I, even doing this kind of work? But I think there is a certain hopefulness to it. And this idea, and this gets to your final question, actually, in terms of what's going to happen. Is there a way around the implementation rock? And I think part of it is they're just not banging their heads up against the wall, but trying to continue to figure out some strategies that might help them do that. Some openings here and there. But obviously in this context, it's going to be very difficult because the pressures against refugee rights are just going to continue and grow even stronger, I would say. Let's see, on Ezekiel's work in terms of educating judges, I don't think it applies, and this would be an interesting point to take up with him next time I see him, but as you say, it's a smaller cadre of lawyers in many of the countries. And I think, as I say, they're just playing sort of defense on actual rights or actual practices, as opposed to trying to move forward in terms of somehow figuring out how to get rid of a lot of judges and bring in more sympathetic ones. They would probably love to engage in that, but they just don't have the resources or the time. The filtering back up to the international arena is interesting as well. My initial thought on that is, we don't have an international, we have some certainly regional international human rights bodies, but not in the refugee law context in particular. And so in terms of the domestic outcomes of cases filtering up, I don't know enough about the inter-American system. Certainly courts in Colombia and Mexico, they'll cite to inter-American court precedent on refugee issues. What I don't know, but it's an interesting question, whether the inter-American court actually will cite now to, let's say, the Colombian case on the right to healthcare. That would be interesting. And I frankly don't know. So why don't I stop there? Why don't we take some other questions? We'd really happy to hear.
Okay, so I had Alyssa. I see Ariel. I have a question. Don't be shy.
I don't like using my, I'll just, so I love this, and I love that, it starts with the mobilization of cause lawyers. I think that's very true. What strikes me is that, the overall limitation surrounding the continuum seems to be xenophobia. And I don't know, at every point, you were kind of identifying where xenophobia puts the brakes on getting to the next stage, or even fully being able to expand whatever stage it's at, which it seems a real challenge, particularly since in all the human rights instruments and just about every constitution, non-discrimination features as a central tenet.
Yep.
And so how do we get around xenophobia, which I think is actually, it almost feels like what the success is kind of hiding broccoli in the little kids'
dinner that they don't realize they're eating vegetables. And at some point they come to discover like, ooh, there's broccoli in this.
Yeah.
Well, I no longer love it and push it aside. And then you have kind of fallback. So I don't know. What do you do with the
How do we hide the
challenge?
broccoli? Yeah, boy, well, and that's a question I would ask a lot of the, most of the lawyers, because they identify that this is a real problem. And that politicians and the media foment that, because what's interesting is that the public opinion data in many countries shows that a majority of respondents across the board favor the right to asylum and the right to find refuge. What gets messy is when folks are characterized as abusing that system, and that you've got people who are seeking asylum, but they're really just making it all up. But if there were a way to kind of harness that acceptance of non-citizens who are seeking protection, and translate that, or not exploit it, but utilize that in a way. That's what I think what a lot of the lawyers are trying to do when they're sort of individualizing things and personalizing stories. That's of course what we do as lawyers too in our pleadings. Sometimes it can be a bit tricky. We tend to focus on victimization, certainly in the asylum context, and the more victimized somebody is, the better chance they have of getting protection, and that's problematic. And certain positions that maybe they would not rather be in, or at least characterizing in that way. But I think that individualized approach, but how does that work in, an era of social media, mass communication, et cetera, it's like one person at a time versus forces on the other side. It is much more powerful weaponry, but that's the weapon that a lot of advocates are trying to use. The other thing I would say, and I know many people in this room have thought about this, is you just knock your head against the wall sometimes when you realize the economic benefit that all non-citizens, but asylum seekers, refugees have, and many studies have shown this. And you have certain business, lobbies saying, agreeing, but it doesn't help us get around the xenophobia that impacts the politicians and the decisions that they make. I didn't mean this to be a total downer. Anyway.
Yeah.
So I want to follow up on the educating judges.
Yeah.
One is, if you look around, there's not a single constitutional law professor. So if we talk here that your talk was about the constitutional aspects of the production of toilet paper, all the constitutional law professors would be. Because you put comparative human rights, international constitutional law, refugees, the constitutional law professors are in something much more important than this. So they don't have to engage in this conversation. So I want to ask you more about the legal education and the role of legal academia in this. It's impossible, at least in Mexico or in Colombia, to teach constitutional law if you don't teach international human rights law, is part of your constitutional class. So that's one. But the other aspect of educating judges, at least my experience in Latin America, is what American lawyers refuse to do. That is to bring human rights arguments in front of judges. And you bring the human rights arguments in front of judges in part to educate. It's not only the judicial strategy of advancing your case, but it's also a way of socializing the human rights argument. My frustration when I talk with American lawyers is what you said, that the judge will believe that you are crazy or they will laugh. But all this creativity that you mentioned in other countries, the American lawyers refuse to be creative on using more human rights arguments, even if they lose the case. That many times they end up losing the cases without using the human rights arguments. So I would like, if you can unpack more that at the end of the day is lawyer in all the other countries with 8 years of experience litigating refugee or asylum cases can never say, I don't know anything about human rights. Nobody would hire that person to represent them. So what is the identity of those lawyers and what's the identity here of those asylum seeker lawyers?
Yeah. Yeah, that's really interesting, both of those points. The legal academia question, that we could talk for quite a while in terms of what should be included in the constitutional law syllabus and all of that. And in my immigration law survey course over the years, I've introduced more and more constitutional law. I mean, part of it's almost necessity because more and more cases of this nature heading are decided by the U.S. Supreme Court, but also matters of citizenship, et cetera, and how they tie in with constitutional rights has become more and more important. So maybe, incrementally, we'll get a little bit more to the place that you're identifying. The point about U.S. lawyers not sort of pushing, not educating U.S. judges in this way, I fall victim to that, right? Even with all the work that I've done, I said how jealous I am of lawyers in Colombia, Mexico, wherever that have access to these human rights arguments. But when push comes to shove and we have an individual case where we're trying to, get asylum for this person, we're worried that, but if this judge is just completely turned off by this international human rights argument, they're going to say, why are you wasting my time with this? And again, you may not have a very strong case under the Refugee Convention, but the lawyers in Mexico who I interviewed said, sometimes you have to take those losses, right? That's hard to convince an individual client. It gets into the duty to your individual client versus the larger cause. And this is actually an issue with cause lawyering in general. Oftentimes, the interests of the client align with the cause, and that's great. But there are many instances, this would be one, but another is, let's say, in a completely different context, let's say class actions, where you bring the class action. I used to do consumer protection law. So you're, something against large credit card companies or something like that. You've got some large principle you're fighting for, but they offer attractive settlements to individual members of the class or the named plaintiff. They want to take it. Your duty as a lawyer is to say, maybe we'll fight this battle somewhere else. But that's a dilemma that cause lawyers across the board face. But it's definitely a difference in the legal cultures and legal academia, and certainly between the U.S. and Latin America. Yeah, and UK too, because it was this one lawyer in the UK had this saying, you don't want to over egg the pudding, classic British kind of comment, by putting too much into your pleadings, i.e. human rights stuff, because you'll just get laughed out of court.
Karen. I actually have sort of a two, maybe both of the answers, if not the questions. So one is, and I apologize because I'm sitting here trying to catch up on the book, but Denise said the one copy checked out. But
You have to get more copies to the library.
Words, please. But so one question is about the continuum, sort of continuing also some of Dan's comments, and the other is about the definition of cause lawyering, which I see is on page 17. So, the book jacket says, the book proposes a theory of a continuum of even more ambitious methods through which cause lawyers use constitutionalized human rights law to benefit refugees. And when you started explaining what constitutionalized human rights were, I understood that that it was principally, even though you sort of talked about the US a little bit, but principally taking international human rights law and bringing it into the Constitution, which is part of why you have those constitutional lawyers knowing more human rights law. But I kept waiting. I mean, it was fascinating. I loved the presentation. And as you went through and assigned the numbers, and then, I was all convinced on Colombia until you told us it was. And I was like, where is he going to put the US?
Yeah.
And so when you came up with the 4 and then said, but with limits, I wasn't convinced, because I thought that was putting, it was provocative, but I wanted you to say a lot more about that, because it also would start to explain again why US lawyers would say there's no reason to talk about human rights. Because apparently, if we understand the continuum, not, the little bit you get enforced is sort of one way to talk about it. But then I heard Denise saying, well, and Dan to a certain extent too, like, well, but actually maybe we need to reach out beyond, and lawyers are certainly feeling the need to do that. So that was one question. And then which might not be totally different. Well, there's an overlap with the cause lawyering question. So when you were going through what the lawyers were doing or seeing as their strategies, and this is an issue with maybe so I don't think of most of the people doing immigration and asylum law in this country as cause lawyers. And I say that.
Got a little-
That's good.
Yeah.
That's a good one. Because it's more direct representation, and it is taking the person who walks into the clinic or the office where you get appointed to. So when your third one was they want sympathetic clients, that, and you just said something a second ago too, that was about, right, you don't always get that choice, but so I didn't know if it was just, we do better when we have sympathetic clients, or some cause lawyers in some areas of law get to choose their clients. And then the people who are then people are sort of doubly screwed, if we could say it, because not only they don't get representation, and then they get results that permanently don't address their concerns. So maybe I'm misunderstanding.
No, I don't think so. Those are great points. I mean, believe me, I hesitated significantly when I thought it was the US is number 4, the highest grade in the class. But it's really what you said at the end of that part of your comments about because it was less about the scope of the rights, because then you could look at the scores or the number of provisions in the national constitution that Zach Elkin and Tom Ginsburg, have identified in their constitutional law study. But it's really about how well those laws are enforced, or implemented, how the decisions are implemented. So in the US, they have been, but they're very, very limited. Due process. I mean, social and economic rights, they're not even on the table for the most part. I mean, yes, asylum seekers get work authorization after a certain amount of time, but that's not based on any sort of constitutional right. That's just statutory. But in other places like South Africa, that was a human rights law based argument. So, so the score, the 4 again is really about the how much the right has been implemented, or whether it's been implemented at all. But that's why I have the caveat, but in a very limited fashion. So, but yeah, so that's where that comes from. Yeah, in terms of the cause lawyering and how that fits into this, and it's interesting what you say about immigration, most immigration lawyers in the US not being cause lawyers. And I think, in terms of the definition of a cause lawyer, I think that probably is true. I mean, I think a lot of people are drawn to immigration law because of the cause of immigrant rights, for sure. But how much they're, able to consciously do that when they're representing individuals is wholly another matter. The lawyers is a much smaller group who get to work on sort of the larger issues, the constitutional rights, or perhaps international human rights. And that's who I was focusing on in the study. But they're, whether or not, but then the question of choice of clients and how does that work, right? And as some of you may know, there's a very organized appellate bar in the US that really looks at which cases, right, to bring to the circuit court level and ultimately to the US Supreme Court. They're very deliberate about that. And the sympathetic nature of the clients certainly play into that. I mean, there may be a principle that goes, that means that they can't pick a sympathetic client, but I think it certainly plays into it. So I think at that level, there is a bit more of luxury, whereas in clinic or, other forms of individual representation, you don't have that luxury always of who's the most sympathetic client. And also the client who may be sympathetic the first time you meet them, after a few sessions, they may become less sympathetic because of what else you find out about their case or what the government already knows about their case. So you have less control over them. But thanks.
We should probably wrap,
Yeah.
at least for my gang, our gang. But if other people want to.
How about, what if people just
If you-
state their questions and then we can sit around and talk afterward? Is that?
Go ahead.
And for our class,
Go
if
ahead,
you need to
Michael.
leave, you are released.
Yeah.
Thank
But I
you
mean,
all.
let's just, yeah, so, okay, but then if people are gonna start leaving.
That's all right. Don't leave until the questions start.
And then applaud, and then we'll.
Yeah.
Okay, Mike.
So, there is cause lawyering to some extent. But the Legal Services Corporation restrictions.
Yep.
On the ability to take cases of individuals who are undocumented and so forth, cuts off the basic supply of cause lawyering in many ways, and it becomes so complex. I was on this commission at a few times, and it just had pieces of the Legal Services Corporation taking one position, another part of the Legal Services Corporation taking a different position. And it just became impossible to have representation. It was because intake is trying to maximize availability of services. If you can only do intake of people who are permitted to be represented under the act, it just makes the intake very, very difficult.
Agreed.
How about we conclude there and then.
Yes.
Okay.
Yes.
And also, students, you're welcome to come ask questions.
Yeah, absolutely. Absolutely.
Thank you.
Place that people were saying, oh, no, I'm not. Or was everyone else saying, I'm a constitutional lawyer, I recognize it's human rights. That seemed to be like,
Yeah.
suggestion of like a very conscious awareness of pulling international, even though you're in a very small ground. But I wondered if there was this, like, I'm making strictly a constitutional argument.
Yeah.
But their constitution just happens to
We're going tomorrow.
incorporate all the rights in the Convention on Rights.
Right. Yeah, we don't sponsor
I mean, in other areas of the law, I haven't done this, but in other areas, what people do, there's the right, and then there's like, what does it mean? Right, and for that, they look to the comments from the committees, or they look to decisions of international courts, so even the decisions of other domestic courts on the same right, because it's informative about how you should interpret the law, so like, does it include the right? You know, you see what other people have said about the right, to see what other people right? So in that sense, you're making a constitutionally based claim, but the interpretive claim is based on material that comes from the
Yeah. But the other thing that's interesting, it's like how lawyers identify, or what their history is before they get into this kind of work. So like. Like your question, I was thinking, well, I think that South African lawyers definitely see themselves as human rights. lawyers.
Yes.
A lot of them kind of get their feet wet in apartheid.
Right.
Whereas. In the US, they would not.
I want to be clear, you could have said
themselves
so.
as human rights.
Except the works one.
Well.
This is what we get now for dinner, because Mary might have a question. But I don't know cause lawyering in the sense of picking only.
Yeah, no, that was
That
my
part,
part.
I agree, would be less desirable, and I don't think we do that. But in the sense of genuinely seeing the direct representation as part of a larger movement to improve rights, I actually think there are quite a few people who see it that way. Maybe not everybody, maybe not the, single lawyer set out a shingle. Even in the private bar, I would say there are quite a few who see it that way.
Yeah,
Yeah, and I
that,
think increasingly.
I was
so.
not just, I wasn't disagreeing with that. It was just, it was not impact. I mean, you might be doing work,
Right.
so I kind of even wondered, did you talk to the people at the ACLU, the National Immigration Project, or did you talk to Denise and all this? You know, and there was overlap.
Both clinicians and
Like the big
folks from
litigating.
those, yeah, the big league.
But I mean, they have more ways or exercise more ways.
Yeah. I mean,
Right.
yeah, it'd be interesting. I mean, in the US, you could go much more granular because there are these different subsets of.
Right.
Right,
lawyers
right.
doing this
Talk
kind of
to
work.
immigration lawyers. Well, take on this.
Well, we're just so vulnerable. What do they, how do they see it? How do they filter?
Right.
Right.
I mean, it's cause minded, and I think.
But I don't think it's just